I salute you all. Thank you for watching. Thank you for being on this channel. And today's course unit, we are looking at the law of evidence. But specifically, here we are going to look at confessions and admissions. And basically here what you have to put in mind, or what you have to know about a confession. A confession, the good difference that I can give you is that a confession is taken prior to trial, whereas an admission can be taken during what? Trial. So that is the good contrast that I can give you between the two. You get? Confession can be taken even before trial, whereas an admission is taken during what? Trial or during court. You get? So bear that in mind to get the good what? Difference or a good understanding of the two. So we shall start with confessions. And confessions here, the question is, what is a confession? A confession basically can be defined using case law. The good case of Swami versus the Emperor, that is a good case that defines what is a confession, which states that a confession is a statement by an accused person suggesting the interference or suggesting the inference that he committed a particular what? A particular crime or particular act. As we hear, the layman's understanding as we hear a confession is that you confess that actually I killed this person, actually I did this act, confessing what you did. You are telling what the truthfulness of what you did. That is a confession. And basically here we are looking at who can make what? A confession. Those are two key parts. The person that can make a confession is the person who committed the what? The crime. When you read Article 28, 3a, basically says that a person is presumed innocent until proven guilty or until he pleads what? Guilty. You get? So basically any person that is accused can do what? Can make a confession, basically. And also when you relate to section 23 clause 1 of the Evidence Act, it says that a confession shall be made by a person in front of what? Of a police officer at the rank of inspectorate of what? Of police. You get? Or a magistrate. And a confession that is made when those people are not there, that confession cannot be considered in the courts of law. So it must be made in front of a magistrate on the rank of a senior superintendent, inspectorate of what? Of police, or at the rank of a magistrate. Then that's when that confession becomes what? Becomes valid or becomes considered in what? In the courts of law. If it is not made in front of those two people, then that confession is valid, is next to invalidity. So basically, bear that in mind. And the good case that can back up that section 23 of the Evidence Act, the case of Beronda versus Uganda, that is a good case on that, where on the validity of the confession, where bear that in mind. And basically for a confession to be considered in the courts of law, they consider on the elements of a valid confession. And one of the elements, we shall deprive them from section 24 of the Evidence Act, whereby section 24 says that any confession that is obtained through force, violence, threats, inducements, or promises calculated to cause untrue confession is not admissible. Section 24. So basically one of the elements we say that it must be made voluntarily. There must be voluntariness in making the what? The confession. You get? Read the case of Abe Kanyike versus Uganda, where court held that the voluntariness of a confession can be analyzed at trial and must be left to the court. So basically note that in mind. And also another one is that confession that is made under inducements, you get, cannot be what? Cannot be considered by the courts of law. When you read the case of Ara versus Okello, you get, whereby here we see that the accused was having sex with a lady, on a tree and she fell off the tree and died. You get? So he was told to confess that his punishment was what? Was to be reduced. You get? So that was the inducement. That is a good case and a funny case, Ara versus Okello. They were having sex on the tree, the other one fell down and died. So he was told that if you confess, your punishment will be what? Reduced. Since court held that the confession that was made was invalid, reason there was inducements. Get? And where there are threats also, they cannot be what? Their confession cannot be considered. When you read the case of Mwanji, son of Njorege versus R, that is a good case that brings out that where there are threats, the confession cannot be what? Cannot be considered. So briefly, even when you read that the procedure of making a confession or how to make a confession, actually the accused person, these are the procedure that you can follow. The accused person must be cautioned before the confession is being what? Made. Cautioned before the confession is being made. And the police, after recording, the police officer recording the confession should be an assistant inspector of police or of a higher rank than that. Or the person recording must be what? A magistrate, as we have seen before. And it must be made in a language a person understands better. The confessor, the language that understands. And it must be made in a room having two people who will act as what? As witnesses. When you read the case of Asenua versus Uganda, you get? So it must be made in front of witnesses. You get? And it must be ready for the confessor to really admit that I really did that in a language he or she understands better. So note that in mind. You get? So basically that is, and also when you read section 27 of the Evidence Act, a confession must be made against the co-accused. You get? What do I mean? But a co-accused, when we relate to section 27, it says that when more than one person is being tried or being tried joint with other persons and makes a confession affecting himself and others, the court may admit such confession. So basically note that. And the confession must lead to discovery. You get? Discovery of the fact in issue. If it is murder, the confession must lead to what are they looking at in the concept of murder. When you read section 29 of the Evidence Act, which provides that the information leading to discovery of other facts of the commission of other crimes is admissible evidence. You get? Basically note that in mind. You get? And the confession must be free. We have seen 3 of threat C, inducement C, made in front of a police officer, among others. And it must be made under promise of secrecy. What do I mean? That a confession made under promise of secrecy, it is never existing. Let no one lie you that a confession can be made under promise of secrecy. When you read section 26 of the Evidence Act, that states that a confession which is relevant can't be irrelevant because it was made under promise of secrecy. You get? Because if I confess, I can't say that I'm confessing, but let's keep this thing all under secrecy. We can't make it irrelevant. If it is relevant, then the promise of secrecy cannot stand. You get? So there's no confession that can be made under a promise of secrecy. You get? So we have, under confession, we have what they call repudiated and retracted what? Confession. What do we mean by repudiated and retracted confession? Here, basically, what you have to know, or what you have to bear in mind, that a repudiated confession, so it was challenged, or it was portrayed in the case of Tuamoi versus Uganda. This case put a contrast between a repudiated and a retracted. What you have to know, repudiated, as we have had a contract being repudiated. A repudiated confession, this is where a person denies to have made a confession. That is repudiated. You deny that I didn't talk anything, I've never confessed. But for a retracted, this is where a person or the accused person accepts to have made what? A statement, a confession, but seeks and wishes to challenge the truthfulness of the statement that he or she uttered. Basically, you may say that, fine, I confessed, but I didn't do what? I didn't talk like that. I confessed to have killed, but the things that they are telling me, they are not correct. I confessed, like, you understand? You are challenging the truthfulness of the statements. But you say that you confessed, unlike repudiated confessions, whereby you deny to have made what? Any confession. So bear that in mind. And for court, when you read the case of Kasule versus Uganda, here they say that the accused retracted his confession. The court held that a trial within a trial should have been made to establish the truth within the confession and corroborate it with other evidence. Once there is retraction or a repudiated confession, then their court handles a trial within a trial. You get, and corroborate with other what? Evidence. You get, once there is a challenge to the what? To challenge any matters about the confession that they are using as evidence in courts of what? In courts of law. So bear that in mind. So basically, here we move forward to what we call admissions. And the contrast that I gave you, that admission is normally made to do during trial, basically. And when you read section 28, section 16 of the Evidence Act provides or defines what an admission is. Basically, it defines an admission as a statement, oral or documentary, which suggests any interference to any fact in issue or relevant fact, and which may be made by any person and in the circumstances. You get? So basically, we have two types of admissions. Admissions made at the beginning of trial and admissions made without the view of what? Trial. At the beginning of trial, basically here, this is where it is always against the maker as a wave of what? Of proof, and which is brought to the attention of court and may be entered against the party who made the admission. You get? And we have without view of trial. Without view of trial, basically here we see that the party or the statement has to be proven by the party who alleges that the statements were actually made. You get? But relate these things to section 28 of the Evidence Act, which supports that admissions most of the times are non-conclusive proof of matters in question, but they may operate as estoppel under the provision of what? Under the provisions in the Act. They act as estoppels to certain what? Areas. You get? So basically not that. And basically what you have to know, the definition carries the characteristics of an admission made oral, documentary, among others. So bear that in. And when we move further, we see that admissions, when admissions are admissible, an admission can be admissible once it is as a waiver of proof, once the statement is against the interest. You get? Statement against the interest of the maker, and also admissions as evidence of truth. So that's when court admits the admissions. And when you read section 18 and 20, all of them, they show that they show people that can make what? An admission, whereby a party to the proceeding can make an admission, an agent to the party to the proceeding or authorized by such a party can make an admission, a representative can make an admission, and also a person with the proprietary what? Interests can also what? Make an admissions. And what you have to be what we must put into consideration while making these admissions is that the admitting party must be in the capacity that links him to the suit when making what? Admissions. You get? And also when you relate to section 17, still on on what must be considered. Also speaks of person from whom the parties to the suit have deprived their interest in subject of the what? Of the suit. So put that in mind. You get? And basically here what you have to know, whereby when you read section 18 that explains that the statements made by those in positions or liability it is necessary to prove as against any party to the suit are admissions. You get? The statements must be to prove against to the party to the what? To the proceedings. And when you relate to section 20, also in the laymanist, we see that it also elaborates statement made by the person to whom the suit has to be explicitly referred to for information or in reference to the matter in what? Disputes. Basically, all we look at this, we are looking at admissions look to the, must be to against the what? The maker, or against the party to the what? To the proceedings. So we have the exemptions to that rule. The exemption to the rule that admission should be made against the maker. One of them is that if the statement is made in the presence of the adversary what? Party and is not denied by him, then they can be used as admissions and to support the case of the case maker. You get? So bear that in mind. One of the first exemption. The another one is that if the law allows it, for example, under taxation law, assessment of tax is made basing on returns payment made by tax what? Payers. That is the second one. And also, if it is in the case of public accounts, they can be presented by the public officers concerned. You get? So bear that in mind. You get? Those are admissions that are not made against the maker. You get? So we see that when you read section 20 of the Evidence Act provides circumstances in which admissions can be what? Can be made. You get? Basically, they can be made or proven on behalf of persons making it in which would be relevant or between third parties if such person is made, who made it had what? Had died. That is also where third party comes in. You get? So bear that in mind. Basically, we have under common law. Common law says that one doesn't need to prove admissions made by them. You get? That is under common law. And the admissions can be challenged by the party against whom they are made as being untrue, except those that amount to estoppels. So bear that in mind. And basically bear that in mind. And the admissions for them, when you read the case of Sharif and another versus Stenan and others, they say that it says that when admitting statements, the whole statement must be taken, including hearsay, however, and opinions. However much hearsay, they say that is not what? Is not admissible. And the forms of admissions that court may consider, they may consider, for example, in form of affidavits. When you read the case of Recohen, you get the case of Recohen, stated that an admission can be a declaration in wills, rituals, description in agreements, receipts, account, passbooks, maps, if pleadings must be sworn in like what? Affidavits. Then they say that the admissions also from documents. Actually, admissions from documents is based on the general rule, which is the parole evidence rule that acts in documentary evidence, that everything must be put in what? In writing. So basically that's the thing that I can talk about confessions and admissions. Basically they move hand in hand by the kind they are different. So basically not that in what? In mind. Thank you for listening. Anything that is not clear, just put it in the comment section, then we shall elaborate more about it.